And welcome back to Capitol Review. I'm Mark Hall. The Supreme Court appeared to reject former President Donald Trump's claim that he is immune from prosecution on charges of trying to overturn the 2020 election. But what could this mean for his upcoming trial in the district? Joining us now on Capitol Review is Zach Schonfeld. He's the courts and legal reporter with our media partners at The Hill. Zach, welcome back.
Thanks so much for having me.
Hey, Zach, tell us what's happening inside the Supreme Court regarding the former president's immunity case.
Well, I think you're right. I think we saw skepticism from all of the justices, both the conservatives and the liberals, of the broadest argument that former President Trump is making. That is that he has immunity from criminal prosecution for all official acts while in office. Trump says that if he followed that argument, that means both his case in D.C. Needs to be tossed, but he also says that means his case in Georgia needs to be tossed. His classified documents case down in Florida needs to be tossed. But what we saw at these oral arguments was the justices not seeming willing to go quite that far. Instead, I think the basic takeaway coming out of the arguments was that the justices are inclined to provide some sort of criminal immunity. Of course, that would have the effect of sending the case back to the lower courts and potentially sparking a whole new round of legal battles that simply has the effect of delaying this trial past the election.
I mean, if it goes back to the lower courts, does that mean that they're just kind of passing the buck?
In a sense, I think the Supreme Court will come out and articulate some sort of standard here and some rule for what presidential immunity should look like. Not exactly sure exactly how that'll be articulated. I think you saw the justices really exploring different frameworks of how they could do that, trying to separate out what official acts should be immunized and then private conduct that should not. But whatever rule they decide, it appeared that they're going to send the case back to the lower courts, and then it's going to be up to those lower courts to actually apply the Supreme Court's test to the specific allegations in Donald Trump's indictments. So they'll have to decide, were his conversations with Mike Pence leading up to January 6th, was that official conduct that should be immunized? And all of those sorts of questions. So that can simply just eat up more time in what is really a narrow window before the election if this thing is going to go to trial.
So this could impact the trial in D.C. If so, how?
Donald Trump, if he retakes the White House after November, he has said that he will, either try to self-pardon himself or even just try to fire special counsel Jack Smith, who has been the lead prosecutor on this case. So effectively, his goal is to grind all of these criminal indictments to a halt. So that's why, this question of whether the trial is going to happen before the election is so important, because if Donald Trump does take home a victory in November, there's a chance that this case will never go to trial. Now, of course, if President Biden wins re-election, maybe this case will still move forward. But that's why this window is so important, and why, even no matter whatever the standard comes out from the Supreme Court when we get a decision, likely in June, if it still delays this trial until after the election, Trump could still pull out a win here by losing at the Supreme Court.
So, Zach, what happens next?
So at this point, we're waiting to see whenever this opinion comes down from the Supreme Court. The High Court does not announce in advance which decisions are going to come on any given day. They tend to get all of their decisions out by the end of June. I should also note that this was the last oral argument of the term, so this is all the way at the end. So the question now becomes, do the justices do what they normally do, wait until the end of June to get a big case like this out? Or do they take Jack Smith's request and act more expeditiously? He has cited some of the cases stretching back to the Nixon era involving Watergate, where the Supreme Court was acting quickly. Jack Smith has urged the Supreme Court to similarly do so here. But I should also note that Jack Smith, before the argument, had been making various requests to speed up the process at every turn. And the Supreme Court has rejected some of those requests. So now the question is back on the table. Will they take his request to speed things up this time?
Zach Schonfeld, thank you very much for joining us on Capitol Review.
Always a pleasure.